To speak, you have 10 minutes, Senator.
Thank you very much, Chair. It gives me great pleasure to introduce the Employment Equality Amendment No. 2 Bill of 2013 in the House this evening. And I would like to welcome Minister Kathleen Lynch to the House and to thank her very much for taking this bill on behalf of the Government. And I would also like to welcome into the public gallery representatives of many of the groups that have an interest in this bill and that have indeed for many years been campaigning for passage of a bill like this and that are here to see this debate. Among them, the Gay and Lesbian Equality Network, GLEN, the ICTU, the INTO, Labour LGBT, and I know that there are plenty of other groups who will be here, the Equality and Rights Alliance, the Equality Authority, LGBT Noise, belong to USI Open, and the ICCL are also represented here. So we have a broad range of groups here, and I'd also like to welcome Deputy Ivana Bacik. Always good to see members of the other House here, and Deputy Bacik has also been campaigning for a long time for this bill. I'm really proud and delighted to be introducing this bill on behalf of the Seanad Labour Group, and I know my colleague, Senator Mary Moran, who's our Seanad Education spokesperson and who will be seconding the bill, feels the same way. The bill came from an initiative that a number of us took, among them my colleague Deputy O'Riordan, also Deputies Ciara Conway, Dominic Hannigan and John Lyons. And we believed it was important and in line with long-standing Labour policy to bring forward legislation to change the current position as set out in Section 37 of the Employment Equality Act 1998. Now, most of those present will be well aware of Section 37 and of what it currently provides. The section currently provides, it has been amended, of course, by Section 25 of the Equality Act 2004, and in subsections 2 to 6, it allows for certain exclusions of discrimination on particular grounds in certain employments, to allow differential treatment based on a characteristic related to a discriminatory ground where it constitutes a genuine and determining occupational requirement and where the objective of the differential treatment is legitimate and the requirement proportionate. However, Section 37, subsection 1 of the 1998 Act is the contentious provision that this bill seeks to address. And it currently provides that a specific exclusion of discrimination exists for religious, educational or medical institutions which are under the direction or control of a body established for religious purposes or whose objectives include provision of services in an environment which promotes certain religious values. So it deals specifically with religious-run institutions, both educational and medical, and indeed also a third type is religious. The exclusion means that such institutions are not seen as discriminating if they give more favourable treatment on the religion ground to an employee or a prospective employee where reasonable to do so in order to maintain the religious ethos of that institution, or where they take action reasonably necessary to prevent an employee or prospective employee from undermining the religious ethos of the institution. So to put it bluntly, a Catholic Church-run school or hospital can currently discriminate against, refuse to hire, or even dismiss a person from the LGBT community, for example, because their sexuality may be seen to offend against the religious ethos of a church that is intolerant and prejudiced against homosexuality. Similarly, a school or hospital, similarly run by a religious body or a Catholic church, can discriminate against a lone parent employee or prospective employee, again because of religious doctrine against non-marital relationships. Now, this provision in Section 37(1) has been subject to criticism from many individuals, the groups represented in the gallery, and many others, indeed the Human Rights Commission and others, as well as the unions, in particular the teaching unions and Congress. For years, unions have been calling, and civil liberties groups have been calling for the repeal or amendment of existing law, and these calls have been supported by numerous groups, including the National Women's Council and others. And as I've said, it's been Labour Party policy for many years to address this. Section 37 has been particularly criticised because it confirms a controversial decision of the High Court from the 1980s, the decision of Flynn v Power from 1985 Irish reports, usually just referred to as the Eileen Flynn case. In August 1982, and I know the Minister, as everyone else, is well aware of this, Eileen Flynn was fired from her job in August 1982. She had been a teacher in the Holy Faith Convent in New Ross, County Wexford. The reason for the dismissal was that she was pregnant but not married. The dismissal was, in a very dark day for the courts, it was upheld by the High Court on the grounds that the Holy Faith Order was entitled to take action, including this most severe action of dismissal, to prevent its ethos being undermined. So the continued existence of a provision allowing an opt-out from discrimination, effectively allowing and enshrining the principle in the Eileen Flynn case and statute, the continued existence of this opt-out has created a chilling effect for LGBT employees, single parents or any others who work or would like to work within religious-run schools or hospitals and who may be at risk of being seen to offend in some way the ethos of the religion concerned. And it is truly remarkable, given how much Irish society has changed in the last few decades, that people working in schools and hospitals, and as everyone knows, the vast majority of our schools and hospitals do still have a religious ethos, and people still are working in those institutions in fear of such action being taken against them, for having children outside marriage, for being gay, or even being divorced. So for a range of reasons. We believe the chilling effect must be challenged, and the climate of fear must now be consigned to the dustbin of history. Deputy O'Riordan put it very well today, saying that as a teacher he knows only too well about the chilling effect Section 37 can have on staff, with people afraid to be open about their private life amongst their peers. But it has also denied many young LGBT people of role models in their classrooms, as it prevents teachers from being open about their sexual orientation. I know Senator Moran will speak more about that very practical impact. So that's why last week we got the unanimous support of the Labour Parliamentary Party for the bill, and then on Thursday published the Employment Equality Amendment No. 2 bill, a piece of legislation that amends Section 37(1) and significantly raises the bar which employers must reach if they wish to discriminate on the grounds of religious ethos. And we hope it will receive the support of all parties. And I do believe it will, because I know that the need to challenge homophobia is accepted across the political spectrum, and indeed by independents as well as parties. And I know I've been glad to receive support from Senator Norris, Senator Zappone in particular, in principle for this initiative. But the programme for government itself stated 2 years ago that LGBT people should not be deterred from training or taking up employment as teachers in the state. And so we believe that the passing of the legislation will represent a key programme for government commitment. But I have to say that there's also been previous attempts by other parties. This is not just something that government parties believe. There's been previous attempts by other parties, and I just wanted to pay tribute especially to Senator Averil Power, who's sitting across the House, from Fianna Fáil, who published a draft bill last year seeking to do the same, to amend Section 37. Sinn Féin, indeed, have also published a similar bill in recent weeks. As I say, I want to commend Senator Power, because when she put the bill forward, it was very important that the issue was then kept alive on the political agenda. That was hugely important. Had the bill not been put to a vote, I think it would very likely have been developed further as government legislation, and I hope we'll see that outcome from tonight. But while I think we should be very supportive of all these efforts to amend the law and to keep the issue alive, it is important that whatever the legislation that is introduced would cover all of the grounds of discrimination in the Original Employment Equality Act, all 9 grounds, not just the ground of sexuality or marital status, but also, of course, family status, also disability and all the other grounds provided for. And our bill will cover all of the groupings in the existing equality legislation. So we'll cover all those grounds of discrimination. So what does the bill do? And I just want to address briefly what its content. Its key purpose is to protect individuals against discrimination in an appropriate and balanced way, whilst respecting religious freedoms. The amendment to Section 37, subsection 1 proposed would offer protections to staff of religious-run medical and educational institutions to a far higher degree than at present, but it does still allow the institutions to maintain their religious ethos. However, it provides additional protections for employees or prospective employees where health or educational institutions are in receipt of state funding, and that's a critical distinction made. It must be said that both the Irish Constitution, Bunreacht na hÉireann, and relevant EU law make it clear that a balance must be struck between individual rights and religious freedom. So the bill seeks to recognise that balance, but also to seek to ensure that the private lives of teachers and health workers should never be used against them again. It's short, it contains just 3 sections. Section 1 and 3 are technical sections. Section 2 is the substance of the bill, providing for the amendment of Section 37, subsection 1, and inserting a new Section 37(1). The new Section 37(1) would preserve the right of religious, educational or medical institutions to discriminate by giving more favourable treatment on the ground of religion to employees, or indeed by taking the action described earlier to prevent employees from undermining religious ethos. However, so that right is preserved. However, a new part of Section 37(1) provides that where an educational or medical institution is state-funded, that institution cannot give more favourable treatment on religious grounds unless such treatment does not constitute discrimination under any of the other grounds, and unless the religion of the employee is a genuine, legitimate and justified occupational requirement. So it sets the bar much higher in respect of favourable treatment on religious grounds. Similarly, the bill also provides that a state-funded institution cannot take action to prevent the undermining of its ethos unless, by reason of the employment itself or its context, the action taken is objectively justified by a legitimate aim and the means used are appropriate and necessary. And there's a final provision in the new Section 37(1) that provides for a presumption of discrimination. In other words, an additional hurdle for a state-funded institution to get over if it seeks to justify any discrimination. Now, Thank you, and I'll just want to address this point because I know the drafting may appear somewhat complex or cumbersome, and indeed the equality legislation is a rather complex is rather complex in its entirety. But frankly, the legislation is somewhat conservatively drafted. I would have liked to go further in the bill, particularly in respect of the undermining of ethos provisions. But we were advised that the requirement in the EU Directive 78 of 2000 requires a somewhat more conservative approach. And Article 4 of that directive gives protection to the right of churches to require individuals working for them to act with loyalty to the organisation's ethos. However, there is some, I understand there is some suggestion that that requires a more conservative approach that's taken in the bill, albeit it's radical in that it covers all the grounds of discrimination. I would personally favour a more robust approach to protect equality in the second aspect of the new section 37.1, where we're dealing with the undermining of ethos. But I think it's something that we could really tease out at committee stage, and I would really welcome the input and comments from colleagues on both sides of the House on that particular issue. And indeed, I know that once the bill goes through second stage, it will have to be referred to the Attorney General and Parliamentary Draftsperson. So I hope we can see then a more robust approach. I know the ICCL have described the bill as creating a partial thaw in the chilling effect. Well, I hope it goes somewhat further than that. I think it in fact creates very significant additional hurdles for any religious-run school or hospital which seeks to justify discriminatory treatment. So it undoubtedly secures much greater protections for employees or prospective employees of such institutions. And I'm really glad that members of the LGBT community and the teaching profession particularly have welcomed this, but indeed the unions and the National Women's Council and others also welcome in principle this issue. The Labour Party in government, just to finish, I should pay tribute also to Minister Rory Quinn, who's already produced an action plan on bullying to tackle homophobic bullying, to Neil Ward in his office, who's been hugely helpful on this, and indeed to Ministers Alan Shatter and James Riley, who've made it clear that they're determined to see the commitment in the programme for government fulfilled. Sadly, Eileen Flynn passed away in 2008. She didn't see an end to the legal discrimination that she suffered, but this bill, we believe, will ensure that no teacher or health worker will suffer her fate again, and I commend this bill to the House. Thank you.